Good morning, Europe. Good afternoon, Southeast Asia. And welcome to our webinar on how to take advantage of international treaty when applying for patent in Southeast Asia. I am Marta Bettinazzi, and I'm going to be the moderator today. But before we start, I would like to guide you through briefly on the function of the system the platform we are here today. On your screen on the right, on the control panel, you will have a part about questions and chat. If you have any question during the presentation, please don't hesitate to ask. We are going to monitor the control panel. And at the end of the presentation, there will be a designated moment for your questions to be answered by our speaker today. And we are looking for a very alive presentation, and we hope that all of you will have questions to ask, and we will answer. However, anyway, please consider that you can also ask questions after the webinar, and they will be answered via email. Also, please note that the webinar is recorded and is going to be put on our YouTube channel. Finally, during the course of the presentation, we will ask you some questions about your patents, and so we will have a more interactive discussion. So now I would like to have a look at our agenda. If we can, yeah. So now this is our introduction. I promise to be very short, and then there will be the presentation until 10:30. And finally, we will have a Q&A section. As I said, if you have questions during the presentation, you can always ask, and if needed, we can intervene. Finally, before we start, we give the floor to our speaker, I want to shortly introduce our services. We are the IPR SME Helpdesk, and we offer services for free to small and medium enterprises from Europe that wants to do business in Southeast Asia. We cover the protection of intellectual property, and we are a query helpline, so always is going to be answered in 4 days. Organize activities on site and at the moment, given the situation, mostly online. Spread the knowledge about IP, and you can also always consult the materials on our website. We have a guide and fact sheets to give you the basic, but also interactive, very funny e-learning modules that you can train yourself with on our website. So without further ado, let me introduce our speaker, Miss Yeng Chang, and she is a lawyer with more than 10 years, a patent attorney with more than 10 years of experience, and she has been practicing in Singapore in many IP departments. She also, she's not just expert on Singapore, she also has a significant knowledge about Myanmar, which is a very peculiar system per se. And so she's one of our best experts on patents. So I'm very happy to have her here today. And so for now, I will just give the floor to Wang to do a presentation. So Wang, the floor is yours.
Okay, thank you very much, Martha, for your kind introduction. I hope everyone can hear me well. My name is Yeng, and as introduced, I'm a patent attorney. I'm based in Singapore, and it's a pleasure to be speaking on behalf of the Southeast Asia IPR SME Helpdesk again today. So also a very good morning to everyone who's joining us here from the Asia time zone, as well as good afternoon to all from the Asia time zone, and good morning for all of you joining us from the European time zone. So Very quickly, we'll go through the agenda. It's quite straightforward what we are going to cover today. Basically, I will go through with you various options that you as a patent applicant could make use of to shorten and accelerate the patent examination process of your applications in the Southeast Asia region. And before we go through the two main options that you could use, which is the Patent Prosecution Highway, as well as the ASEAN Patent Examination Cooperation, I would like to talk to you a bit more about the standard examination process so that when you understand that, you know how these two options can help with the shortening of the process for your applications in the Southeast Asia region. And last but not least, we also will go through quite briefly some of the other options that you could use to expedite the examination process of your applications in the Southeast Asia region. So as a small and medium enterprise, it is not unusual that you are not that familiar with the patenting process, with the examination process of patents. You might have not yet filed any patents yet, or you might have a modest patent portfolio that is only filed in the country that you're based in. So to understand this examination more fully would be very beneficial for you, because this will allow you to come up with a patent strategy that will be more suitable for your business needs. This is something that I would recommend that you discuss with your patent attorney. Your patent attorney will be able to give you options as to whether you want to lengthen the examination process or to shorten the examination process. So for today's presentation, we are only looking at ways to shorten, to accelerate the process. In certain cases, it is actually beneficial that you might want to lengthen the process. One of the reasons might be that you have limited cash flow and you do not want to pour all your money into the cost of patenting, but you want to stretch it out for 4 or 5 years rather than to have to incur all the costs within 2 years. So going back to this slide, the patent office, when they receive a patent application, will determine whether your application fits these 3 main criteria for patentability. So they will assess whether your invention is new, your invention is obvious or not, and whether it is useful and industrially applicable. So how does a patent office does that? What happens is when your application is filed with the patent office, a particular patent examiner is assigned to assess your application. He will conduct searches to look for applications that are similar to yours but are already known or are out there in the market. They will compare your invention with these known other inventions that are similar, and they will come up with a final conclusion, which is to allow your patent application to grant or object it based on certain reasons. So the reasons will be more or less your claims, your invention is not new, or it is not inventive, or it is not industrially applicable, which is these 3 criteria that were listed earlier. And you as the applicant will work with your patent attorney to craft the arguments and make some amendments to your application so that it fulfills these 3 criteria, and hopefully you obtain a patent grant after this process. This process can take several rounds. So sometimes it might be you receive 3 different objections from the patent office, and so you have 3 opportunities for you to submit arguments or claim amendments to your application. And when we talk about this examination process, and that it might be an iterative, in terms of the number of times that you have discussions with the patent office, you would like to know how long does it take. So I've extracted some information from the US Patent Office as well as the European Patent Office. From the USPTO, we see that it takes about 2 years. So it's the top right-hand corner of the 4 boxes on the left, 23.6 months to examine a US patent application. And in fact, on the chart next to it, you can see that if you break it down between different tech sectors, certain tech sectors will take a longer time to examine your patent application. So if you file a patent application relating to computer architecture, the time frame for examination is longer than the standard 23.6 months. It is closer to 30 months. And vice versa, for communication, it is shorter. So maybe I think around the region of 19 months for the examination process to conclude in the USPTO with the USPTO. And for the EPO, this is what I've extracted from their website. They state that it takes about 44.3 months. That is quite a long time, nearly 4 years, for a patent application to grant from the date of filing with the EPO. I'd just like to clarify that the time frame that the EPO measures is not exactly the same as the time frame that the USPTO measures. The USPTO is measuring specifically the examination stage of the application. So your application goes through various stages, and the EPO in fact calculates the complete time from filing all the way to grant. So there are certain other stages that this 44.3 months include. So it's not, you shouldn't assume that the EPO is lower than the USPTO just by comparing 44.3 months against 23.6 months. And now that we understand each patent office will have a patent examiner assigned to examine your patent application. In this example, we see that an applicant is trying to file and obtain patents in 4 different countries: Korea, Turkey, USA, as well as South Africa. This means that there are 4 patent examiners at least that will be examining your patent application, independently coming up with their own conclusions, and you as the applicant will have to file your submissions, let's say claim amendments or arguments, to try to overcome any objections from these patent examiners. And it does feel like there might be a bit of duplication work because the main criteria for patentability is the same across patent offices. All your 4 patent examiners are looking at at whether your invention is new, whether it's inventive or industrially applicable. And if you have an invention with a wide global market reach, this becomes really quite a problem. So over here, the example is the thumb drive, which was invented by Trek Technologies. And these are the countries that I found that Trek Technologies had filed a patent in. So you will have many, many patent offices that you are dealing with. They are all looking at the same 3 criteria and deciding whether to grant a patent to your invention. So what can we do? Or is there any solution or ways to, let's say, streamline this process? So this is the first option that we are talking about, which is applicable to applications filed in the Southeast Asia. So we are talking about the Patent Prosecution Highway, which in fact is an agreement or treaty that patent offices have come to agreement with. And basically, it just means that if you are filing patent applications for the same invention in multiple countries, you can use the results issued by the examiner in one of these patent offices and forward it to the second patent office which your application has been filed. And the examiner in the second patent office will refer to the results. And this will help the patent examiner in the second office accelerate his work, since quite a bit of work has already been done by the earlier patent office. And so the PPH, if requested, is expected to increase the grant rate and conversely reduce the cost that a patent applicant might incur while filing patents in many countries. So to give this to give you a better understanding of how PPH works, we have an example for you here. So let's say you're an applicant and you want to obtain patents with the European Patent Office, and you also want to file and obtain a patent in the Philippines. The good thing is that there is a PPH agreement between the European Patent Office and the IP Office of the Philippines. And in the case of your European patent application, we see that it has already been granted. So with the grant results of your European patent application, you could request for PPH with your at the IP Office of Philippines for your Philippines application. This allows the examiner at the Patent Office in the Philippines to refer to the examination stage of the European patent application. And by referring to all the documentation, let's say the objections as well as the responses submitted for your European application, there is an acceleration of the examination of your Philippines application and hopefully the grant of your Philippines application. So we've come actually to the first poll question of the session. We've talked about the patent prosecution highway and that it can be beneficial in terms of accelerating patent grant because you have already obtained patent grant in another country. So how many Southeast Asian countries offer PPH scheme for accelerated examination? Please go to the poll section.
Yeah, it's already showing on your screen. And thank you, Yeng. And please vote. It's just a way to assess a little bit like how it's your understanding of this kind of system or like accelerated system. We will give you more or less 1 minute, 1 minute and a half. Please don't be afraid. You are here to learn and to improve your knowledge and understanding. So please, and also the vote is anonymous, so we're not going to put you on the bad guy list. So don't worry. You still have another 20 seconds if you want to vote. If you want to tell us what's your opinion. You know, of course, that we have 10 Southeast Asian countries in general. So how many, what's the percentage in a way of them having a PPH system? So 10, 8 or 6, or better 6, 8 or 10. Okay, I think that now we can, a decent percentage of you have voted, so we can now close the poll. And yeah, we see that 60% of the people think that 6 countries have a PPH accelerated examination system in place, while 20% goes for 8 and another 20% goes for 10. So Yeng, what's the right answer?
Okay, I'm starting to think that the participants are more knowledgeable than me. So I have to say that the majority of the participants are in fact correct. The answer is 6 countries have,
okay.
are
we're
already
happy.
yeah, already providing. Yeah. So over here, this is actually the answer to the poll question. Indonesia, Malaysia, Philippines, Singapore, Thailand, and Vietnam offer PPH programs. And if you see on the right-hand side column, these are the offices that has established PPH agreements with the let's say the Indonesia Patent Office. So if you look at Malaysia, Malaysia has PPH agreements with China, the China IP Office, with the European Patent Office, as well as the Japan Patent Office. And Singapore currently is the IP Office with the most PPH agreements. There is a particular PPH agreement which I'm not going to explain too much, but basically it is more like a circle, a group arrangement. So if you are in that group arrangement, it's called the Global Patent Prosecution Highway, and there are 27 countries in that arrangement. So Singapore is part of the global PPH. So because of that, they are able to make use of the results, or they will refer to results from 26 different IP offices to allow the acceleration of the grant of your Singapore application. So because there are 6 that are offering PPH, then these are the 4 countries where PPH is still not available: Brunei, Cambodia, Laos, and Myanmar. So if you are a little more intrigued about the PPH and you want to go about requesting it, these are the basic requirements that must be existing before you can request for PPH. First of all, this is very obvious. You must have filed it in 2 offices, because basically you are using the results from the first one to accelerate the examination in the second patent office. And that the first office must have at least found some of the claims of your patent application allowable. Let's say the first patent office had decided to completely reject the application, then obviously your second patent application will not be able to be accelerated based on the results of rejected application filed in the first office. Then another thing that you need to take note of is that you cannot request for PPH when the second patent examination is midway during this examination stage. You must request it before the first office action or the first objection has been issued. So very quickly, these are the benefits that you could gain from requesting PPH. You will have a faster grant of your patents, and then a larger portfolio in a shorter time frame. Because the patent application has already been deemed patentable in another country, in another foreign patent office, it's quite obvious that the grant rate will also be higher for your second patent office. And then because the claims are already accepted in another office, it means that the objections that you will receive in the second patent office will be lower. So these are the benefits that you can expect from requesting PPH. And I think we go straight into the next poll question. So if you've been paying attention, with your request for patent prosecution highway, we are saying that the grant rate is improved. So what would be the current grant rate of Malaysia and Thai patent applications if PPH is requested? This is something that I extracted from the website that pulls out statistics relating to PPH.
Okay, so again, you will have your participants have more or less 1 minute and a half. I would like to address shortly the fact that we are going to talk about more also bilateral agreement later on in the presentation, because there was a question about it, a note about it. So if you still have some concerns regarding this, you can after that part you can ask again the question, and we will cover it. So meanwhile, you still also have the question, the poll question open for you. So let me repeat: what is the current grant rate of Malaysia and Thailand patent application when PPH is requested? 70%, 80%, 100%. We will give you another 20 seconds. Again, there is a right answer in this case, but we are not here to judge. We are here to learn. So please try, make a guess. First time you were quite good, so we expect you to be good again. Okay, let's say that we can show the results now, which is a strong majority for 80%. So B. What's the right answer?
Okay, so it's quite interesting that nobody chose C, which is 100% of our applications proceed to grant. And here is the answer. So, well, it is not that unusual, but 100% of Malaysia applications as well as Vietnam applications proceed to grant if the patent prosecution highway is requested. This is actually
Okay, so
because it has been,
you can say.
yeah, the same invention has been granted in another country. And if we look back at the PPH agreements that Malaysia and Vietnam has, let's go back.
Can we go back to the slides?
Previous.
Okay, we are back.
Okay, so let's look at Malaysia and Thailand. Thailand's PPH agreement is with the Japan Patent Office. And for Malaysia, it's with China Patent Office, EPO, as well as Japan Patent Office. So in this case, the results issued by these foreign patent office is quite persuasive. You know, they have well-established patent offices and experienced patent examiners. So it's actually quite expected that Malaysia and Thailand will also come to the same conclusion as the examiners in these patent offices. So, oh, it's Vietnam, sorry, let's go back. Vietnam. Vietnam is Japan Patent Office and Korea IP Office. So again, Korea Patent IP Office is very well regarded in terms of their examination. And because of that, the Malaysia application as well as the Vietnam application, 100% of it goes to grant if PPH is requested. So we've actually finished covering the patent prosecution highway, and now we'll go into the ASEAN Patent Examination Cooperation, which basically is an agreement between 9 patent offices in the Southeast Asia region. So Brunei, Cambodia, Indonesia, Laos, Malaysia, Philippines, Singapore, Thailand, and Vietnam. And this is great because if you recall earlier on, we said that 4 countries does not have any PPH agreements. And now 3 of these 4 countries are in the ASEAN Patent Examination Cooperation. So at least applications filed in Brunei, Cambodia, and Laos can benefit from having the same invention granted by patent offices, let's say in the Philippines or Singapore. So again, there are certain requirements that needs to be fulfilled when you request for ASEAN Patent Examination Cooperation, or we'll call it ASPEC in this case. It is actually less vigorous than PPH, more lenient, or in other words, you can request for ASPEC anytime before the final decision is issued by the patent examiner. If you recall, the PPH must be requested right at the start before any examination takes place in the second patent office. So this is actually a little bit more lenient. You could request it midway during examination. And the same form is in fact used with no fee no fee payable to the patent office. And there are certain offshoots of the ASPEC program. So there's ASPEC AIM and PCT ASPEC. I will go through that quite briefly. Again, if you want to know more in detail, talk to your patent attorneys or speak to us at the IPR SME Helpdesk. So some statistics at this from the ASPEC website. The first office action is issued. So the first either allowance or acceptance or rejection from the patent examiner is issued 8.1 months when ASPEC is requested. This is much faster. If you recall, for USPTO, it takes 2.4 years. So imagine perhaps there are two office actions. Maybe one office action is issued a year from the request. And over here, the first office action is issued 8 months from the request. And currently, right now, the allowance rate at final decision is 100%. So very encouraging if you want to use, if you want to make use of ASPEC. So this is another statistics that I've obtained from the website on information relating to ASPEC. Quite a number of applications are filed where the applications in Indonesia, Malaysia, Philippines are accelerated based on the examination results issued by the Singapore Patent Office. So this is what I'm trying to say here. ASPEC requests are filed predominantly when the first office is Singapore, and then the second office will be the one in Indonesia, Malaysia, or Philippines. So as I said, ASPEC AIM is one of the offshoots of ASPEC itself. Basically, it targets the Industry 4.0 inventions. So as an applicant, if you have inventions that are related to Industry 4.0, which could be quite broadly explained as Internet of Things, as well as architecture and infrastructure relating to Internet of Things. If you request for ASPEC, the examiner will treat this application even faster than normal ASPEC. So instead of 8.1 months that we talked about earlier, the first office action will be issued within 6 months. This is because the countries or the patent offices have come to agreement and they want to prioritize examination of Industry 4.0 inventions as they are really cutting edge technology, and they feel that it is really beneficial if the applicant can get a grant of inventions relating to this technology faster rather than later. You might want to take note that there is a cap of 50 applications under ASPEC AIM per year. And again, there is no additional official fee to be paid, and the same form is used when requesting ASPEC in. For PCT ASPEC, actually, I think I will just skip. It's more or less the same. You use examination results issued by one of the patent offices that have been listed earlier. So one of the 9 patent offices. And once there's some allowance or some claims allowed, you could use that to obtain acceleration of your patent application in a second patent office. So we've also covered now the ASPEC option of accelerating the examination of your Southeast Asia patent applications. So actually within each and every patent office, there are also other ways that you can expedite or to get the grant of your patent quicker. So for example, in Cambodia, we have accelerated decisions as well as direct grants. Direct grant is something that's quite, I think, quite interesting. So basically, direct grant means that there is no examination at all conducted by Cambodia. So you want to contrast that against ASPEC as well as PPH. PPH and ASPEC still requires examination to be conducted in the second patent office. What happens is that your patent examiner in the second office makes use of the results in the first patent office, and then it allows him to come to a conclusion faster. But for direct grants, there is no examination at all. There's an agreement between the patent officers such that once you have a patent granted in Singapore, you will be able to obtain a patent in Cambodia just as long as the suitable documentation is provided to them. So similarly, there is a direct grant option for patents in Laos, and it's based on Singapore patent that is granted. And in Malaysia, there is the modified examination, which is sort of could be considered quite similar to PPH. So for modified examination, you submit also the grant of the patent filed in a foreign patent office. So in this case, it is Australia, UK, Japan, Korea, US, or the EPO. And with the favorable examination report from these patent offices, the Malaysia patent examiner will also conduct an examination which is very much shortened and very likely to be granted, again because the results has been favorable when the application is filed in the foreign patent office. And in some countries or some patent offices, such as Malaysia and Singapore, you can request directly for accelerated patent examination independently. So as long as you request for accelerated patent examination, the patent examiner will shorten the entire process. They are not going to refer to any results in foreign countries where you might have filed the application, but it's just that the procedure within the patent office itself is quickened. And conversely, you also have a shorter time to respond to office actions if they are issued. But in Singapore, if you request for accelerated examination based on the Singapore Patent FT program, FT means fast track program, you can actually expect to get a patent granted in about 6 months. I've read some news that a patent was granted in about 3 months in Singapore when accelerated examination was requested. And for Malaysia, there's also the option for you to request for expedited examination, which is the same meaning as accelerated examination. So as a quick summary, we've talked about PPH and as well as ASPEC, as well as some other ways that you can accelerate the grant of your patents in all these Southeast Asia countries. So for Brunei, you can see that they don't yet have any PPH agreements in place, but you could rely on ASPEC agreement. So let's say you filed patent applications in Malaysia and Cambodia, Malaysia as well as Brunei, and your Malaysia application has been granted. Brunei application can request for ASPEC so that the patent examination in Brunei is accelerated and the examiner refers to the results the results of the Malaysia application to issue a examination report faster. And again, there are some other ways that you can get a grant of your application in Brunei if we refer to the earlier page. So we've talked about this in rather abstract terms. We'll give some examples, but there are actually patent applications that have requested for PPH and have been granted as a result of requesting PPH. So these are 3 applications that are extracted from the patent database of Singapore. And if you look under the column PPH examination requested and the next column examination report issued, you can see that the examination report is issued quite quickly after PPH has been requested. So just about 4 months for the first application, about 5 months for the second application, and six months for the third application. So this is really quick compared to standard patent prosecution timeframes. And then you can see the result of requesting patent prosecution highway. The first two applications immediately were granted. The second one, unfortunately, some objections were raised by the examiner. And so you go through the process again of perhaps amending the application, submitting some arguments to try to overcome the objections by the examiner. And this is statistics that I extracted from IPOS, the Intellectual Property Office of Singapore. So maybe I think we'll just want to see the grant rate, first allowance grant rate, which is the chart on the left bottom corner. It does reflect that, in fact, not all applications go immediately straight to grant when PPH is requested. Only 50% of them goes to grant immediately, and then the rest of them will have an office action issued, and the applicant will need to overcome the objections by the patent examiner. So this kind of ties in with the three examples given earlier. So two of them went straight to grant, and the third one, there are rejections, and well, right now we still are in the midst of examination, so the final result is unclear. And based on the first example given, which is an application related to firearms, I also found that the same invention has, the applicant is seeking patent protection for the same invention in quite a number of patent offices. And right now, the US application as well as the Singapore application have proceeded to grant. The others are still pending. And actually, this also ties in with what I mentioned about patent strategy. So certain applications, you might not want to get it accelerated and grant as soon as possible because the fees are rather high. This really is applies to the EP applications. The official fees are very high towards the end of the EP application. So it's just a guess. It could be that the patent applicant intentionally wants to delay the EP application for as long as possible. So the application is not proceeding under PPH. As for the other patent applications, I'm not entirely sure why PPH is requested or not, but as what I said, it is really a decision, and it's a business and commercial decision to request for PPH or not to. So this is actually the last slide of the day. This is a combination of all the things that we've talked about. So we are able, in fact, to seek accelerated grant of patent applications filed in 5 countries in the Southeast Asia region if you have a patent granted in the EP with the EPO. So starting from the left, the EP application has already been allowed or granted. With that result, and if you have filed applications in Philippines, Singapore, as well as Malaysia, you could request for PPH based on the EP application and obtain the grant in these countries. And earlier on, I said that Cambodia as well as Laos has an agreement with the Singapore Patent Office. So if you have a patent granted in Singapore, directly you will have a grant of a patent in Cambodia as well as in Laos. All you need to do is to submit necessary documents. It's just a matter of formalities. No examination is conducted by Cambodia or Laos. So you can see that if you are aware of all these various options that you could use to accelerate or hasten the grant of your patents in the Southeast Asia region, with that you could actually get the grant of patents in 5 countries in a rather straightforward and quick manner. So that's all for today. Thank you very much for your time. I think we are opening the floor to Q&A.
Yes, yes, indeed. So I encourage everyone that still has questions that has not been addressed by our expert discussion to pose it now. So the first question I see is if there is any disadvantage with requesting a PPH or an ASPEC or accelerated examination in general. So we saw quite a lot of the advantages, but are there any disadvantages in this kind of programs?
Okay, so it's this was also somewhat covered earlier. One of the disadvantage of requesting examination in an accelerated form is that the fees relating to to the patenting of your invention is all condensed in a shorter time frame rather than the 4 years. As we can see, the EP application, if progressing normally, takes about 4 years to grant. So any cost that is related to from filing to grant is condensed from, let's say, 4 years to 2 years. It might affect the cash flow of the applicant. And this actually has happened to one of my applicants because of COVID. So their business was very adversely affected by COVID, and they have a problem with cash flow. But before COVID happened, they didn't think that there would be any problems with cash flow. They wanted all their applications to proceed under PPH, and because of that, all the office actions were being issued left, right, center. You need to incur costs to review the office actions, to file responses to the office actions, and at the time where cash flow is a problem. So you need to take that in mind when you request for PPH. That is cost is one thing, manpower is also another thing. Let's say you are filing patent applications in 10 countries and you requested for PPH. Very quickly, you get an office action from the examiner, and you have to deal with all of them on a accelerated basis. Let's say you only have 2 months to respond to them or 3 months to respond to them. Do you have the employee or yourself able to have the bandwidth to address so many office actions in a short period of time? This is actually quite intensive, so you might have to read a lot of documentation to understand the objections from the patent examiner and to come up with suitable responses. So second is manpower. Then there is actually a third disadvantage, which is a little technical, but that when you accelerate the examination of your patent application, there could be at a later stage new materials that are found by the patent examiner which might be adverse to the patentability of your invention. What I'm trying to say is because everything is condensed so quickly, if the examiner missed out certain similar inventions, then the examination might not be completed as thorough as you want it to be. One of the other thing is some of the patent applications might not yet have been published, and if they are not yet published, they are not considered known inventions, and these sort of inventions are actually considered prior art and will destroy the novelty of your inventions. I think this is slightly technical, but yeah, something that you might want to take note of. And again, whether to accelerate or to extend the time of the application of your patent application can be tied quite closely to your commercial purposes. So it is an advantage and it can be a disadvantage based on whether this fits with the commercialization time frame of your product. So I hope that addresses the question.
Yeah, I think it's very interesting to understand for a company that there are many options. And as a company, like with the help of a lawyer or a patent attorney, you should be able to choose the most beneficial way for patenting or not patenting your invention. So there is a lot of thought about it. So I see another question that is, when the PPH or SPH is requested, would the patent examiners from Office of Later Examination discuss the examination results with the patent examiners from the first office? So it's a question about like how they talk between each other, the office, how is the communication of the office working?
Okay. This I think maybe is you envision if you request for patent prosecution highway, then it sort of opens a channel between the patent examiner from the first office and the patent examiner of the second office, and they start emailing each other or discussing with each other, and it helps the examiner of the second patent office to come to a conclusion. So actually, this is not the case. This is when requesting for PPH is really a submission of documents to the second patent office. There is no channel open between the first patent office and the second patent office. The examiners are not going to be discussing the patent application at all. It is only the examiner of the second patent office. They will receive documents, just all the reports from the first patent office, and they will independently and individually be reading these reports and then coming up with their own conclusions themselves. So yeah, in short, by requesting PPH, it doesn't mean that you open a channel of discussion between the examiners. All it means is that you are able to submit documentation of the first patent office to the second patent office, and the patent examiner will review and consider the results because PPH has been requested.
Okay, so basically it's a document exchange, so you're not going to like start an opening discussion. With this,
it's a one-way also. Sorry, just to be clear also, even if it's a document exchange, it's a one-way thing. So documents don't get sent from the second patent office to the first one. Yeah.
Okay, so that's very interesting. So if there is no other questions, since there is no other question, I will proceed with thanking Yeng once more for this very interesting presentation, and to making like an interesting presentation out of a very complex and technical topic. So I thank her in the first place, and I want to thank all the participants again for being here today and spending part of your day talking with us. It's also a nice moment, I think, to mention that we are going to have another event the 8th of September. We are going to have a webinar on Smart City. So I will be glad to see all of you there again. It's the same time as this one, if I'm not mistaken, so it's still 10 a.m. Central European time, and 15 in the Asian, Southeast Asia, Vietnam time. So with that, I would say that I will be glad to have you again with us. Please have a look at our website and keep in touch. If you have further questions, don't hesitate to contact us. The presentation is going to be on YouTube. So Yeng, thanks again for this very interesting presentation, and I wish you all a very nice day. Bye.
Yeah, thank you very much again, Martha. Bye.